Hello and welcome to Talking Legal. I'm Praveen Gautam, trusted growth partner. So essentially what I do is I help businesses and entrepreneurs to build a digital brand and monetize it. Today in this Talking Legal episode, we're talking about interesting topic on a divorce. So obviously the very interesting time. So we want to know more about of the divorce. A lot of our communities has been asking about the know-how. That's why I have got special guest today, Laura. Good day, Laura.
Hello, Praveen.
Great to have
How are
you today. All
Thank
good,
you.
thank you.
Good to be here.
Likewise. Now, let's start with obviously interesting with this COVID happening, and no matter where our viewers are watching this from, they are very curious to know what they need to know about divorce. So so in a simple way, let's start with very, very basic question: who can apply for a divorce, Laura?
Okay, so that's really easy, Praveen. So either party, either spouse can apply for a divorce. They only have to be Australian citizens or a resident of Australia. So either party. This includes same-sex couples as well. So they can apply for a divorce as
Right.
well.
Now, that's good. So as long as they are citizen of Australia and no matter whether male, female, they all can apply. Okay,
Yeah.
that's good. So is that what these are the basic grounds, or what would you think? What are the basic grounds for that divorce, Laura, please?
Yeah, so the grounds are that the marriage has irretrievably broken down. So this means that the parties have lived separately and apart for at least 12 months and there's no prospect of reconciliation.
So the key dates is literally 12 months. They have to be apart,
12
is it?
months. Yes,
Is that
12
also
months separation.
okay? Is that also meaning of a separation? Is that 12 months? Is that separation, or what exactly the meaning of separation is then, Laura?
Okay, so the meaning of separation is more than a physical separation. It's when both parties or when one or both parties forms an intention to separate or not to resume the marriage, and that intention is acted upon. So, and it must be communicated to the other party. So it's more of an action and conduct of one of the parties that they no longer wish to be in the marriage.
Right. So, and obviously it has gone through the communicative way, right?
Yes.
Oh,
You have to
okay.
have communicated that intention with your other spouse, say, I want to separate.
Okay, beautiful. All right, so that gives a very clear idea. Now, if you are just watching this right now from different social medias, including YouTube or Facebook, feel free to give us a thumbs up or comments or specific questions there for Laura. Feel free to just jump in and type it here. Laura Muccitelli,
Yes, that's right.
now finally I get to pronounce well.
Yes.
She's online and she's a special family lawyer working in Matthew Love. So that's good. Okay, so that gives a clear idea for our viewers now. Now, other thing, let's get a little bit deep dive, Laura, if that's okay. Can we live separately under the same roof? So it's what's your thought on that?
Okay, yes, so some couples do, although they communicate that they wish to separate to their spouse, they live together in the same roof for various reasons. There might be financial reasons. Neither party can afford to move out of the family home, and that is okay. So if a party wishes to file a divorce application, they need to also file an affidavit saying that addresses the changes, so a few evidence. So changes to the sleeping arrangements. Are they in separate bedrooms now? Do their family or friends or children know that they've separated? Do they attend social gatherings together? Do they perform domestic duties for each other? And what is the level of financial dependence on each other? So do they have separate bank accounts, or are they still supporting each other? Basically, the rule is the greater the degree of separation of the lives of the parties, then the likelihood that the courts will grant the divorce to say that they fit into the criteria that they have separated.
So I would imagine there must be at least a couple of criterias, isn't it? Not just one, but there must be a 3, 4, 5, is it?
Yes, there's a couple of criteria. You need to provide evidence via an affidavit from the spouse, so yourself if you're applying, and also a corroborative evidence, so an affidavit from a friend or family that knows that they've separated. So the friend's affidavit can say, I've known Shelley for 10 years. I've known them as a couple. I've been to their house. I see that they sleep in separate bedrooms. I see they don't share meals together. All their friends know that they're separated. That type of evidence would lead to the court granting the divorce application, because it proves that although they're still living together, they are clearly separated.
Right. So then that brings the next question here, Laura, is when will the divorce take effect, literally?
Okay, so it takes effect 1 month after the divorce has been made. So exactly 1 month. So when parties file the divorce application, they get a hearing date. They don't have to attend that hearing date if it's a joint application or they've got children over the age of 18. At that court date, if the application satisfies all the grounds for a divorce, then divorce will be made. And then 1 month after that date, it will become into effect. So that means that 1 month they can't remarry. It's probably the largest effort of the courts if they want to reconcile, they can reconcile.
Right. So I'm sure in your such a long career in your legal, have you seen any of those cases? I mean, month, obviously couples get together and then, yes, if there's anything.
No, I haven't seen those cases where they've gone to divorce and then during that month they reconcile. No. If I could just say further, Pravin, that month is it can be shortened with the court can shorten that month. So, and I have had a case a while ago that my client was married and was living in a de facto relationship. So she's been separated for many, many years. She just never got round to her divorce.
Right.
She found out her current partner had a terminal illness, and they wanted to get married before he passed away. So, and he was quite ill when she came to see me. He was literally had weeks to live, and she couldn't wait for the 1 month because he would have passed away during that month. So we did apply to the court with an affidavit from him and a doctor's evidence to say, he's got a terminal illness and we would like the 1 month to be shortened. And the court did grant that, and it was shortened to about a day. And then she got married. She got married the next day, a couple of days later.
Wow. So obviously special considerations based on a case by case, yeah?
Yes.
Okay.
Exactly.
That's a very clear, and I hope that's giving a very clear message to our viewers here. Now, always when you talk about the personal or family matters, there is always a cost attached to it, and when people talk about legal, and some many time we get scared, So tell me about how much it cost.
Okay, so nowadays, if you go onto the Family Court website, you can actually do your divorce online on their website. And I do encourage people, if they're able to, then they should do that. It is very user-friendly. Otherwise, obviously, if you get a lawyer to do it, you're going to have to pay their professional fees. Some of their professional fees range between, say, $1,000 to about $1,500 in professional fees, depending obviously on what lawyer you engage. On top of that, you're going to have court fees. So at the moment, the application for divorce carries a court fee of $930. That's right. So that is quite high. Unfortunately, that's the court fee. However, the court does have, they can reduce that fee to $310 if you're on, say, a pension card, healthcare card, or also if you pay that fee, then you'll be under some hardship. So they do have some discretion to reduce that fee. But there is, yes.
Yeah, but they have to show all the proof, or there is a special special form or link they have to form, I would imagine.
Oh yes, exactly. So if you're saying that you're under financial hardship and you can't afford the $930 fee, and you're not on a pension card or you don't have a healthcare card, you're just you're busy with kids, you're busy paying mortgage and other expenses, then all you need is just to prove what your expenses are, bills, loan agreements, credit card debt, things like that, and inevitably the courts will listen to that and use their discretion and perhaps reduce that fee for you.
Right. Now, thank you, Laura. I think that has given a very good idea for our viewers. Now, just to walk me through some procedures of. There must be some procedures, on the divorce procedure. So, would that be okay if you just walk us through, please?
Yeah, sure. So no problems at all. So the first part, if a party is thinking about applying for a divorce, is that the marriage has to irretrievably broken down and they must have separated for 12 months. So no prospect of reconciliation. Okay. You log on to that party, goes to the family court website, and you fill in the divorce application. You attach your marriage certificate, and you pay the fee. Okay, or you get a fee reduction, whatever, if that applies. You will get a court date straight away. Now, there's certain things you need to do before that court date. You have to serve the other party. Okay, so we call that the respondent. You need to serve them 28 days before that hearing date. So, and the party that files cannot serve the application directly on them. You can't do that. You need to get a process server to do that, or a friend or someone that can file an affidavit of service to the court. So the court will want to know that the other party knows about the hearing date, because that's really all service is. It's really notice. Okay. I should say also that if you're married less than 2 years, when you file the application for divorce, you must have attached a counselling certificate with that application as well.
So what you're saying is under 2 years, you have to put the counselling applications, yeah, if it is under 2 years.
Yes, because that's a short marriage, and the courts want to see that you've actually attempted to resolve the issues between you, really.
Yes.
Okay. So once you serve the other party, then you're fine you'll have a hearing date. So you can attend that hearing date. You don't have to. If you've got children under the ages of 18, you must attend, okay? And because the court will want to know that you've made arrangements for their care, welfare and development. Okay, so who the children are live with and what time the other party sees the children, what times. So they want to make sure the kids are okay.
Absolutely.
All right. If you have been living under the same roof for a certain amount of time, you also must file with your application, as I talked about before, an affidavit setting out the circumstances of your separation. As we talked about before, do you have the same sleeping arrangements? Do your family and friends know you're separated? And also that corroborating evidence, that corroborating affidavit from that friend or family member that knows that you're separated. So then, if you don't have any children, and all those other criteria are satisfied, you've been separated for 12 months, there's no prospect of reconciliation, the court will just grant your order. And there's no appearance required at court. They'll just send your order in the post or upload it onto the Commonwealth Courts portal. If you have children, and so you must attend, and the court would ask you 2 questions. You've been separated for 12 months, well, actually 3. There's no prospect of reconciliation, and what are the arrangements for the children?
Right.
And the court will grant if it's satisfied, it will grant the order then and there.
Yeah. So obviously the children's matters as well as the family. So as long as the, through the process is involved there, pretty much, isn't it?
That's exactly right. Yes.
Now, thank you so much, Laura. That is very clear for our viewers. Basic things you should know, but obviously there must be a lot of technical aspects there, and that's where you need a trusted family lawyer, someone like you and your team. So those viewers who are watching this right now, if they want to contact what would be the best way, Laura, please?
Okay, so they can email me directly, just at laura@matthewlove.com.au, or the generic email is just info@matthewlove.com.au. So either way, just flick us an email and I'll be happy to help.
Beautiful. Thank you, Laura. And obviously people can book the time as well through the website, 20 minutes as well as 60-minute consultation. So you still do a phone consultation no matter where the clients are, yeah?
Yes, exactly. Yes, we have half an hour phone consultations at any time. And obviously if people still feel that they need to have a face-to-face, we are doing face-to-face for an hour in our office in Capalaba.
Okay, so that's in Queensland, obviously. But the viewers who are watching this from other parts of the cities, definitely through online or virtual way. Yeah. Beautiful.
Oh, excellent. Yes, I do Zoom meetings as well, Skype meetings, so no problem.
Thank you so much, Laura. Now, before we close this meeting, do you have any other anything we haven't covered on the basic things on this topic, divorce?
No, I've got no other comments to make, other than to say that parties should just bear in mind that divorce just ends your marriage. It doesn't have any. If you want issues resolved in relation to your property matter or issues resolved in relation to your children, then you do need some advice about that.
And that's where the trusted family legal team or family lawyers would need it, because obviously divorce comes with not just the paperwork, but it comes with a lot of things as well attached to it, isn't it?
It does, yes. Exactly.
Wealth, families, kids, a lot of things involved.
Yes,
so taking time and having a trusted legal advisor is a good way. For sure. Exactly. Thank you so much, Laura. Thank you for your time. I hope this has been value to you. If you like this video, feel free to give a thumbs up, comment, or share. And if there's any specific questions, feel free to just type it down, and Laura and her team can definitely address. Thanks for watching, and bye for now.
See ya.
Thanks.